Welcome back to True American History. Here we dive into history, not just scrape the top of the trees. Today, we continue as we dive into the United States Constitution. Our focus for this episode will be Article 1. So who really runs the federal government? We the people elect individuals to represent us and to make the laws. So let's take a look at why Congress looks and acts the way it does. So in Article 1, Section 1, it creates two-chamber legislature. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Short, sweet, to the point. Section 2, this section focuses on the creation of the House of Representatives. This House shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualification requisites for electors of the most numerous branch of the state legislature. Basically, this is saying that every 2 years, representatives shall be voted on, and the rules for these elections are based state to state. For the largest group of body, legislature, or the lower house, which is the House of Representatives. No person shall be a representative who shall have not obtained the age of 25 years, been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he or she shall be chosen. Now, seats are divided by population. In the antebellum era, there was a compromise that was included known as the 3/5 compromise. So what is the 3/5 compromise? It was a population counting rule from the Constitutional Convention in 1787. It said that enslaved people would be counted as 3/5 of a person for two things only: representation in the House of Representatives and direct federal taxes. An important note is the rule did not give rights or votes to enslaved people. It did not say their lives were worth 3/5. It was a political formula for dividing seats and taxes among the states. Here is how the math would work. The state's population total included all free people. It excluded untaxed Native Americans. Then it added 3/5 of the number of enslaved people. For example, if a state held 100,000 enslaved people, 3/5 of that is 60,000. So the state's apportionment total increased by 60,000. Now, why does this matter? Well, counting 3/5 increased the representation of slaveholding states in the House. It also increased their electoral votes for the presidency, because the state's electors equal its House seats plus 2 senators. Now, the political effects: there were more seats meant more committee chairs, more votes on tariffs, banks, and slavery policy, and a stronger hand in choosing the speakers and presidents in the early republic. So here's a few other links to other compromises that had came about. At the convention, the 3/5 formula was part of a larger deal. Large states got population-based representation in the House. Small states got equal representation in the Senate. And the slave trade question was postponed with a separate 20-year window on congressional bans. Now, when vacancies occur, they are filled by special elections within those states. The House also chooses a speaker in order to be the leader of the House. This person is known as the Speaker of the House. This person is voted on at the beginning of each congressional session. And one of the biggest powers that the House actually holds is they hold the sole power of impeachment. Section 3, the Senate. Each state has 2 senators. Each of these senators serves 6-year terms. The terms are staggered in order to make sure that they have overlapping information and service. A senator must be at least 30 and a citizen for 9 years. A historical note, in the antebellum era, state legislature actually chose the senators instead of them being elected by we the people. The Vice President of the United States shall be President of the Senate, although shall have no vote unless they are equally divided. The Senate shall choose their own other officers and also a president pro tem in the absence of the vice president from the chamber, or when he shall be exercising the office of President of the United States due to an incapacitation of the actual president. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be under an oath or affirmation, and when the President of the United States is tried, the Chief Justice of the Supreme Court shall preside over the trial. No person shall be convicted without a concurrence of 2/3 of the members present. Judgment in cases of impeachment shall not exceed further than to remove from office and the disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall, nevertheless, be liable and subject to indictment, trial, judgment, and punishment according to the law. Now, Section 4 goes over the times, places, and manner of holding elections for senators and representatives. This shall be prescribed in each state by the legislature of each state thereof, but the Congress may at any time by law make and alter to such regulations, except as to the places of choosing senators. The Congress shall assemble at least once in every year, and such meetings shall be on the first Monday in December, unless they shall by law appoint a different day. Now, that was the original. In the 20th Amendment in 1933, this was changed, and it did move the required annual meeting of Congress from the first Monday of December to noon on January 3rd. Additionally, this move ended up providing for a uniformed federal election day in November. Section 5, Rules, Discipline, and the Journal. Each house shall be the judge of the elections, returns, and qualifications of its own members, and a majority of each shall constitute a quorum to do business. But a smaller number may adjourn from day to day, and may be authorized to compel the attendance of absent members, in such manner and under such penalties as each house may provide. Each house may determine the rules of its proceedings, punish its members by disorderly behavior, and with the concurrence of 2/3, expel a member. Now let's pause right there real quick and take a look at this. So basically what the beginning of section 5 is talking about is each house, the Senate and the House of Representatives, at the beginning of each session, they will deliberate on the rules of their house, how they will handle discipline, what rules will be put in, and how would they be enforced. This would go to as far as expelling a member. So if you have a member which is causing issues on the floor of Congress, who is breaking their oath, this is a term in a way of impeachment of a senator or a representative. However, these rules can change each year. These rules can change depending upon who's in charge. So they may be a little lighter one year, and the next year they could be a lot more stringent. So each house shall keep a journal of its proceedings, and from time to time publish the same, excepting such parts as may in their judgment require secrecy. The yeas and nays of the members of either house on any question shall, at the desire of 1/5 of those present, be entered into the journal. Neither house, during the session of Congress, shall, without the consent of the other, adjourn for more than 3 days, nor to any other place than that in which the two houses shall be sitting. So therefore, if the House wishes to adjourn for more than 3 days, let's say a week or 2 weeks, then the Senate must agree to that. If one wishes to go and hold a hearing or hold a session of Congress at a specific location, for example, we have seen Congress go down to the border to be able to have hearings at the border. We have seen them in other places where they have gone so that they get eyes on the current situation of what is going on in certain areas. Those have to have the consent of each other in order for them to be able to go and do those things. Within each of these journals, nowadays, we have a little thing called the internet, where websites can end up holding these journals and the publishing thereof to the public. So it's not something that you necessarily have to go and request unless it is something specific that you're needing to use, say a Freedom of Information Act, in order to be able to get more information on it. Or actually writing a specific congressperson for specifics in the background or other information which may be available. So, Section 6, the senators and representatives shall receive a compensation for their services, to be ascertained by law and paid out of the Treasury of the United States. They shall in all cases, except treason, felony, and breach of peace, be privileged from arrest during their attendance at the session of their respective houses, and in going to and returning from those respective sessions, and for any speech or debate in either house, they shall not be questioned in any other place. Now, this is something that is extremely important to understand. They cannot be detained or impeded from being able to get to the session or return from the session of their respective houses unless it is treason, felony, or the breach of peace. If it is one of those three things, they can be arrested. There are many misnomers out there that a person who is in Congress, whether it be the Senate or the representatives of the House, cannot be arrested while they are in session. If they break the peace, they conduct a felony, or they conduct treason, they can be arrested. Even on the floor of Congress, they can be arrested. No senator or representative shall, during the time for which they were elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the emoluments whereof shall have been increased during such time. And no person holding any office under the United States shall be a member of either house during its continuance in office. Now, what does all that mean? It means basically you are hired, elected to a position, and therefore that is the position you are to hold. You are not able to hold an additional position to be able to make a bigger income from the government. That's also known as double dipping. So this is placed into the Constitution to avoid that from happening. Section 7. How a bill becomes a law. All bills for raising revenue shall originate in the House of Representatives. They hold the power of the purse. But the Senate may propose or concur with amendments as on other bills. Every bill which shall have passed the House of Representatives and the Senate shall, before it become a law, be presented to the President of the United States. If he approves, he shall sign it. But if not, he shall return it. This is known as a veto, with his objections to that house in which it shall have originated, who shall enter the objections at large on their journals, and proceed to reconsider it. If after such reconsiderations 2/3 of the House shall agree to pass the bill, it shall be sent together with the objections to the other House, by which it shall likewise be reconsidered, and if approved by 2/3 of that House, it shall become a law. But in such cases, the votes of both Houses shall be determined by yeas and nays, and the names of the persons voting for and against the bill shall be entered on the journal of each House respectively. If any bill shall not be returned by the President within 10 days, except for Sundays, after it shall have been presented to him, the same shall be a law. In other words, if Congress gives the President a law for his consideration and signature, he has 10 days, excluding Sundays, after which it has been presented to him, in order to be able to sign it and return it. And if he doesn't do that in that timely manner, then it is the same as if he was to have signed it, and it becomes law. So in like manner as if he had signed it, unless the Congress by their adjournment prevents its return, in which case it shall not be law. So if during those 10 days Congress decides to adjourn and it's not returned to them because they're in an adjournment, then that does not become law. Every order, resolution, or vote to which the concurrence of the Senate and House of Representatives may be necessary, except on question of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 of the Senate and House of Representatives, according to the rules and limitations prescribed in the case of a bill. Section 8. Enumerated powers. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts, and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. In other words, they can make these charges and collect money in order to be able to provide for the defense, which is our military, which is now Department of Homeland Security, things of those nature, and the general welfare. General welfare at this point is not talking about welfare as we know it today. The general welfare that they're speaking of is roads, defense, abilities to vote and have governance. Those are some of the things, not limited, but those are some of the things in which they are talking about within general welfare. They have the right to borrow money on the credit of the United States. This is one of our big issues where it comes to our national debt. To regulate commerce with foreign nations and among the several states, and with the Indian tribes. To establish a uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States. To coin money, regulate the value thereof and of foreign coin, and fix the standard of weight and measures. So when it comes to the value of our dollar, what exactly that means, Congress has that power to be able to determine what the weight of our currency, what our money is against foreign currencies within our country. We can't dictate that onto another country. However, if it's being exchanged within the United States, this is stating that Congress has the power to regulate that value. To provide for the punishment of counterfeiting the securities and current coin of the United States. So they have the ability to be able to say whether somebody that is counterfeiting any kind of monetary valued coin, paperback, bonds, anything of those natures that can be used in a monetary value, that the Congress has the ability to provide the punishment, what that punishment would be. Okay? They also have the right to establish post offices and post roads, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries, to constitute tribunals inferior to the superior court. Now, this is very important. In the Constitution, the only court which is established by the Constitution is the Supreme Court of the United States. It is the only one in the U.S. Constitution. However, it does state that Congress can create inferior, meaning lower courts, as deemed necessary. And we will get to those further into the Constitution when we get down to the judicial branch. So, to define and punish piracy and felonies committed on the high seas and offenses against the law of nations. So they do have the ability to define what we know as admiralty and maritime law, and to be able to use those on the high seas only. To declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. So they are able to actually make the rules on how we would handle POWs, or prisoners of war. To raise and support armies, but no appropriation of money to that use shall be for longer term than 2 years. Now remember, this is when it was established before, where we didn't have an actual standing army. So to raise and support armies, but no appropriation of money to that use shall be for a longer term than 2 years. They had where they could only use that appropriation money for 2 years to establish the army. To provide and maintain a navy. We had to protect our coastline. We had to protect the trade that was going on with other countries and piracy. To make rules for the government and regulation on the land and naval forces. To provide for calling forth the militia to execute the laws of the Union, suppress insurrection, and repel invasion. So this is where not necessarily having a standing army after the 2-year term, originally they had it to where they would call up a militia if it was needed. And this still stands today, because that militia, which was also known as Minutemen, are also now today our National Guard. So they are still able to be used to execute the laws of the Union, suppress insurrections, and repel invasions. Basically, you're looking at this particular version of the time of the military at that point was the militia would be called up, would end up protecting the country until an army was able to be raised as regulars. Okay. To provide for organizing army and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states, respectively, the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress. So although the militia was left to the states to manage and to train, the authority, the standards, and the disciplinary actions was prescribed by Congress, not by the states. To exercise exclusive legislation in all cases whatsoever over such districts not exceeding 10 miles square as may, by secession of particular states and the acceptance of Congress, become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. Let's pause right there real quick. The district they're talking about, not exceeding the 10 miles square, is the District of Columbia, which was designated as the nation's capital. And to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested in this Constitution in the government of the United States or in any department of officer thereof. Section 9. Limits on Congress. The migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808 or 1808. But a tax or duty may be imposed on such importations, not exceeding $10 per each person. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it. This particular piece is extremely important to understand. If there is a case of rebellion or invasion, the privilege of writ of habeas corpus may be suspended until it is laid down. No bill or attainted or ex post facto law shall be passed. No tax or duty shall be laid on articles exported from any state. No preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another, nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another. So in other words, if you had a vessel that was going out of, let's say, Louisiana and was going to go around Florida and head to Europe, it did not have to stop in Florida, unload, clear, and pay duty on their cargo before proceeding on to Europe. This was completely unconstitutional at this point because it defeated the purpose of becoming a United States. No money shall be drawn from the treasury, but in consequence of appropriations made by law, and a regular statement and account of the receipts and expenditures of all public money shall be published from time to time. Now that leaves a gray area of what time to time actually means. However, the rules in which Congress would end up implementing each session determines when that time actually is that they would end up posting those. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of Congress, accept of any present, emolument, office, or title of any kind whatever from any king, prince, or foreign state. So when you see a president, a secretary of whichever office, a congressperson, any one of those that are visiting a foreign dignitary in another country, or they come here and they bring a gift, in order for them to be able to keep that gift, it must be passed by Congress and approved by Congress for them to be able to keep it. Now, in the definition of emolument, office, or title, this means money, a office within another country's government, or title, king, adversary, prince, esquire, all those kind of things that are titles from other countries are illegal according to the Constitution. And that the Congress is the ones that would have to approve any of these things that would come from the United States will not grant them whatsoever from the United States. So we have no titles of nobility from the United States government. Section 10. It limits on the states. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payments of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. So a lot of these are, in that particular paragraph, are reiterated from other sections within Article 1. No state shall, without the consent of Congress, lay any impost or duties on imports or exports, except what may be absolutely necessary for executing its inspection laws, and the net produce of all duties and imposts laid by any Senate on imports or exports shall be for the use of the Treasury of the United States, and all such laws shall be subject to the revision and control of the Congress. This appears to be a control of Congress over the states as it pertains to duties and taxes for imports and exports. This is also, as we were mentioning in section 9, of being able to control one state taxing another state within the Union. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter any agreement or compact with another state or with any foreign power, or engage in war unless actually invaded, or in such imminent danger as will not admit of delay. Now, this last paragraph is huge when it came to the Civil War. This one paragraph is where all the southern states ended up breaking the Constitution, and technically at that point committing treason just off of that one paragraph. So let me read that paragraph one more time. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops, or ships of war in time of peace, enter into any agreement or compact with another state. That right there is exactly what happened with the Confederate States of America. They entered into an agreement and compact with other states to create the rebellion, or with a foreign power. So in closing, Article 1 is the engine room of the federal power. It builds Congress. It defines what Congress can and cannot do. It basically puts the right and left limits, or the boundaries, in what Congress is able to do legally. It prevents the states from fragmenting the national system. Now, with that, need to provide some clarity on a definition. If you go back and refer to our previous episodes on acts of authority, you will find how these acts play out and where the writ of habeas corpus was used. A writ of habeas corpus is a court order that requires a government official, like a sheriff, a warden, or other authority, to bring a detained person before a judge and justify why that person is being held. It basically is a demand for the government to prove it has a legal reason to keep someone in custody. And if it can't, the judge orders the person's release. The purpose of this writ is to protect against unlawful imprisonment. Additionally, is to ensure there is due process, that a person cannot be held without a valid charge. Now, if we go back to the Civil War time frame, the writ of habeas corpus was placed on hold. It was suspended due to the fact of the insurrection and rebellion that was going on at the time. Due to that fact, if you were to have people that were creating internal treason, you don't know one person from the other as to who is an insurrectionist or a rebel and who is loyal to the Union. So therefore, President Lincoln had suspended the writ of habeas corpus. Additionally, at the same time, he had suspended basically the Constitution at that time due to the fact of the internal war. As we go through the Constitution, we will find that there are many things throughout history that many portions of our Constitution have stood out, have weathered the test of time, and has been challenged through every generation. And I implore you to come and complete this journey with us as we go through each article of our Constitution to see and understand what are the depths that our forefathers put together in this Constitution, the framework for our nation. And are we truly living up to it? So thank you for joining us on this episode. And we would like for you to help support us. If you liked what you saw, please hit the like button. If you enjoy our episodes, please subscribe so you don't miss any ones in the future. And if you also really liked them, please share them with everybody you know. And if there's a specific area that you would like for us to study and to look at and to be able to do an episode on, please leave it in the comment section. You could also leave us a comment on what is the most important portions of each episode that you hold dear, that you think is the most important, or a question that you may have for that particular episode. And we will try our best to get back to you. This episode is brought to you by Indigo-Enterprises Limited. We thank you for joining us today, and may God bless each and every one of you, and God bless America.